Dr. Barrett.
I'm obliged, my Lord. Having before the short adjournment covered the context, the last thing I promised, my Lords, that I would do before getting to the case under each of 13(2)A and B was to address why it is that in my submission there's a very limited role for general considerations of policy in motivating a reinterpretation of those provisions of the statute. First, we say, and I'll take this very shortly because I've said it in writing already, that this isn't an appeal about how best to resolve policy questions about AI and its role in innovation in the UK, and nor is it an appeal about how best to use the patent system to promote innovation in the AI sector. Those don't form any part of the considerations that led to the Act being drafted in the form it is, that are set out in the Banks report, and that, in the AI context, is quite unsurprising for what is, after all, a 1977 Act. But a more concrete point, perhaps, is that the Patents Act 1977 has been amended several times since its original reenactment, including at least 5 times in the last decade. None of those amendments is germane to anything that you have to decide, but it's not as if Parliament hasn't had opportunities to update or reconsider any part of the Patents Act 1977. They have, and they've chosen not to legislate for the changes that the appellant urges. And the submission gets more concrete still because Parliament has made express provision for authorship and ownership of computer-generated works in statutes that concern other intellectual property rights. My Lords, if I could ask you to turn up page 349 of the bundle. This is section 9 of the Copyright, Designs and Patents Act 1988. Page 349. Paragraph 3 of the section says, in the case of a literary, dramatic, musical or artistic work, those are the general categories of work that can be copyright works, which is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Then on page 351 is the corresponding interpretation provision in section 178, which defines computer-generated, about the 4th entry, in relation to a work, means that the work is generated by computer in circumstances such that there is no human author. So that's copyright. Then finally, at page 354, we have the Registered Designs Act 1949, and its section 2 in particular. Paragraph 4 of that gives you an exactly corresponding provision in my submission. So 2 points arise from that. First, Parliament plainly thought that it didn't go without saying where property lay or where credit should lie in a machine-devised work of intellectual property. It considered that that needed further statutory provision.
Well, one can't simply read across the circumstances underpinning the Copyright and Designs Act to the patents world.
That's absolutely fair. No, of course.
Because authorship in...
No, it's not the same thing. No. But I say that they had this sort of problem in mind. They decided to make express provision because they thought express provision was needed in the context of copyright and in designs, and they didn't decide to make that choice. Or perhaps, I can't help you with which, they may have decided not to make that choice.
Or that it wasn't necessary at this stage.
They may have thought it wasn't.
Because the Act deals with it adequately already. We simply don't know, do we?
We can't know. We can't know for sure, no. But I say that in circumstances where they thought that it was necessary to say that it's not clear that the fruits of the thing belong to the person who owns the thing and that's the end of it, they clearly didn't think that was a general rule that applied in intellectual property. And so they thought they had to make express provision, and they didn't do so in the context of patents. That's as high as I can put it, and I wouldn't seek to put it any higher.
Because you would accept that a patent doesn't necessarily result from the sort of skill and effort that you need to put into the creation of a copyright work.
Yes, of course, they're different tests.
Yeah.
I don't seek to make a submission that they are the same and you can read across absolutely. I simply say Parliament had this sort of problem in mind. They thought it was something that needed clearing up. There clearly wasn't a completely general rule across intellectual property. They thought it needed statute provision, and that hasn't been done in the context of patents. That's as high as I can put it, and I wouldn't seek to go further. Fundamentally, I say it's not reasonable to invite this court to wade into what is a multifactorial assessment in a very complicated policy area of interconnected problems, one that's controversial and topical, without, my lords, having been provided, perfectly properly not having been provided, with all the materials that that sort of assessment would need. The Comptroller fully agrees that the role of AI technology in our lives is only going to increase, and that considerations of it in a policy context involves difficult conversations, even about the most fundamental questions about rights, liabilities, where and with whom they should be located. There is very good reason for those conversations to take place holistically, precisely because they are so fundamental, and to take place with the benefit of representation and evidence from all different types of stakeholders who might be either involved or affected or suitably knowledgeable. And so fundamentally, the Comptroller says if changes to the law are necessary, then they are for Parliament to evaluate and to make, taking all of that background into account. And there's a related but distinct point about the role of the questions you're being asked to consider in the context of the patents scheme in particular. The policy questions adjacent to this case and pointed to by the appellants aren't just questions that are relevant to general issues of AI. On one view, what's sought in this case is a refashioning of what it means to be an inventor, what it means to invent, indeed, for the purposes of our patent law. Now, plainly, the notion of what it is to invent is central to the entire scheme of patents. You're being invited to remove or at least reshape a brick very near the bottom of the patents pyramid. And we say that that's a suitably dangerous endeavour, that it's one that you should be reluctant to engage in. We've seen that the basic conception of an inventor in the UK and the EPC context is that it's a person, a natural person. We've seen how that fits with the scheme of inventorship here since as early as the 49 Act, as well as in the EPC. And in due course, we'll see how the drafting of the 77 Act in particular is centred on the notion of the inventor being a person too. Our patent system is a carefully chosen set of balancing incentives. At its base is what this court has frequently referred to in its recent judgments as the patent bargain. A person may choose to disclose his or her invention at the necessary level of detail in return for a right to enforce a monopoly over the working of that invention. Now, whether those sorts of incentives, bargains, and balances transfer properly onto an artificial intelligence probably seems doubtful at first blush, but that's not a question that either I or this court, with the materials before it, are well placed to determine in the context of this appeal.
May I just interrupt you for a moment? I mean, you're presenting that entirely, properly, if I may say so, as a fairly stark choice. But we all know that patents are filed for inventions, the creation of which has involved some very sophisticated equipment,
yes.
Whether it's calculating equipment or computing equipment and so forth.
Yes.
And that may be equipment which is operating under the control of one or more people.
Yes. High-throughput screening, for example, in the chemical context might be the way in which a chemical compound is discovered to have a particular effect and then forms the basis of a patent.
Modelling and so forth.
Absolutely.
All of these things are highly sophisticated pieces of equipment without which the invention would not be made. And so where are we to draw the line when you get to cases on much closer to the boundary between what is or is not an invention for which there is a human inventor?
Well, where the line is to be drawn is where the Act says the line is to be drawn. It's about how the patent is applied for. It's not a property of this invention that has led to the patent not proceeding. It's been deemed withdrawn because the applicant did not comply with the application procedure, as we will see, because it didn't designate a proper inventor.
Well, supposing it had, I appreciate it didn't, but supposing it had designated Dr. Thaler, would that have been, in the office's view, a proper application in the circumstances of this case?
There's an important point to draw out behind that. I will answer your question directly, I promise. The important point is that the controller doesn't take a view about what is the accuracy. We saw the word accuracy in Rule 81 of the EPC, and the same thing is true, I'll come to that when I deal with Section 13 here. The controller doesn't go behind the fact of what he is told. So if a person is nominated, yes, absolutely, what would have happened in that case is nothing. We wouldn't be here. If Dr. Thaler had been put forward as the inventor, that is a person, and it would not be for the controller to go behind investigating whether Dr. Thaler exists, or Dr. Thaler is the right sort of person, or Dr. Thaler knows enough, or Dr. Thaler actually did it. None of that is for the controller to investigate.
That rather undermines the policy matters, doesn't it? Or how is the court to police the accuracy, or how is an assessment to be made of whether or not this was ever devised by human beings?
The scheme of the 77 Act is that will always be an inter partes problem. So when somebody, the whole idea that we saw in the Banks Committee report saying this is all too complicated, getting people to assent to, yes, I'm the inventor, I really did it, and I promise they can make the patent. They said, we're going to get rid of that, and we're not going to have it implied that the inventor assents at all. That implication won't be carried. And instead, you will recall from the passage we read just before lunch, it says we will have to create another procedure for people to be able to get the rights in the patent redirected to them. I deliberately state that in general language, not the language of the statute, because there are several provisions. That can be done before grant by sections 8 and 12. It can be done after grant by section 37. So in the case where the wrong person has been named, the controller doesn't go behind it, and there's a mechanism for the person vexed, if you like, by not being named, to have matters corrected.
And is there a way of testing whether or not it was ever devised by a human being in a material way, such as to satisfy the requirements of the Act?
Certainly not one that the controller has any power to.
But suppose somebody wants to use the invention without paying any royalty or something, and arguing that there was no human inventor, and it's not, so there was no right to obtain a patent. Is that capable of being raised or not?
No, because the two sets of provisions I've just referred you to talk about the right of a person to apply to have their entitlement to the patent redetermined.
So somebody can only apply if they're claiming that they should have the right, not if they're simply saying that there was no right in the first place.
We'll look at it in due course, but yes, I believe that's right. So it's not about the controller always, in every case, doesn't have a business checking the facts of what he's told. The controller asks merely, and this is a distinction I'll draw out more later on, could this be an answer to, assuming it's true, could this be an answer to the statutory question? And if the statutory question is, who is the person or persons you believe to be the inventor, and the answer is not a person, it can't be an answer to that question.
But the controller wouldn't look at the question of whether or not there was a sufficient input by a person to make them a deviser or an inventor within the meaning of the Act.
It's part, the passages we saw in the Banks Committee report are reflected in the 1977 Act. Part of the scheme was deliberately to take away from the controller a role in sorting out the factual accuracy of those assertions.
With respect, there is a difference between deciding between two people who has the better title to an invention, and on the other hand, deciding whether or not it's an invention within the meaning of the Act at all.
Well, whether it's an invention, yes. The question of whether it's an invention isn't through the prism of who invented it. That we agree on. So whether the invention is an invention is a property of the thing that is claimed. And the invention is defined by the claims as Section 125 of the Act tells us. So the invention is circumscribed by the application. Whether that invention is an invention that is patentable is a separate question from, is this applicant entitled to a patent for that application, for that invention, excuse me. One of those is the business of the controller, namely the latter. The former is not, under the scheme laid out by the Act. The point
Sorry, just one more question. I mean, Lord Justice Arnold in the Court of Appeal gave some rather vivid illustrations of how one could put in as an inventor all sorts of made-up names.
Yes.
Mickey Mouse or something.
Yes, we'll come to those in due course. There would be a difference, for example, between Mickey Mouse and the fictitious character Mickey Mouse.
Yes.
If the form said Michael Mouse, it would be, on the scheme under the Act, it would be no business of the controller to question it. We're not in the business of examining the accuracy. If it said the fictitious character Mickey Mouse, we would say that's not a person, that doesn't meet the requirement of the Act. Or I think My Cat Felix was the example we explored, and the judge explored it at first instance, well, on the first appeal too. We'll deal with those in context when we come to, when I look at 13.2a in a moment.
There's no sanction for putting down a name of an inventor which...
No, because the scheme of the Act isn't supposed to be punitive. It's not about punishing people for lying to us. It's about making sure that these property rights are located with the right people. And if they're located with the wrong person, because the wrong inventor has been named, the mechanism by which that is done is not to burden the controller with a process of examining, are you the right person? It's to give the right person the ability to come along to the controller for a couple of years afterwards and say, it should have been me, let's have a process.
So, certainly for my part, insofar as you are able to assist us, I would welcome your assistance as to whether or not, in such a case, even if not a matter for the controller, there is nevertheless an avenue under the Act to secure the revocation of the patent if it has in fact been generated by somebody who is not an inventor, or something which is not an inventor, as in your submission it should be understood.
I think the answer is that it's not, but I'll give that more consideration as we go through the relevant parts under 13.2a. But my instinct is the answer to that is no, we don't have a mechanism for that.
Thank you.
Not under the Act. I mean,
not under the Act, no.
I mean, might there be an extreme case where the Attorney-General could apply to declare the patent void? I mean, that has happened in relation to the registration of companies. There's no mechanism under the Companies Act for, as it were, declaring a registered company not a registered company, but the Attorney-General does have jurisdiction to do it, or power to do it.
Yes. I think the proper answer may be that I'm not aware of a mechanism. I can't rule that out, my Lord, but I'm afraid I'm not aware of any such mechanism existing. The proper answer, I think, to my Lord Kitchen's question may be that whilst there wouldn't be retrospectively a way to revoke a patent for that, it may not arise, because if there's no proper inventor, provided the controller is following the process that I say the controller should be following, then the patent will not be granted. It may be that there are some cases where there is nobody to whom the patent can be granted for something which would be a patentable invention had the right person applied.
Again, last question on this,
yes.
if I may. Knowing what we know now about this application and Dr. Thaler's involvement, so far as it's been described in the papers,
yes,
the controller would not have had an objection, or perhaps would not have had the power to object to this application proceeding in the name of Dr. Thaler.
Proceeding with Dr. Thaler nominated as the inventor.
Beg your pardon.
That's absolutely right. What would have happened if that form landed on the controller's desk is nothing, because nothing in the sense there would have been no objection. We wouldn't be here today, because a person would have been nominated, and the controller won't say, well, was it really him, any more than they do in any other case where it's absolutely clear that it's entirely human involvement. We don't say, well, was it him or was it his colleague Miss Bloggs? And we don't look to see if the person exists. We don't check the electoral roll. We're not empowered to do any of those things.
But the difference is, in the case where there's an actual human inventor, they may come along and challenge it.
Yes.
If there isn't, then they can't, and then it seems to be a bit of a defect in the system.
Well, that may be right.
If there's no possibility of correcting it, should it be inaccurate?
Well, I'm not sure it is inaccurate, because what's stated on there is that comes to what we're defining an inventor as. The inventor is the person who actually devised the invention. If there wasn't a person who actually devised the invention, then there's no inaccurate information that goes up in that respect. Because if somebody applies, if there is no proper human who can apply for a patent in a given case, then the outcome will be that no patent will be granted.
Well, that is, as long as the person says so, but if the person applies, you're saying there's no filter on that.
That's right. Yes.
And in your case, paragraph 105, you say that Dr. Thaler could apply in his own name, and he could give further specification that the invention was devised with the use of Davis.
Yes, so that would be, excuse me, my lord, I didn't mean to talk over you.
Not at all.
No.
No, you answer first, and I will ask supplementary.
Super. The answer first is yes, that is exactly what we're suggesting, and in the patent's specification it could say that. So that would be available to the world. They don't need to write in the inventor box, no, Dabus is the inventor, in order for the world to see that Dabus was used to devise this invention, not least because who the inventor is, as my Lord Kitchen put it to my learned friend earlier, that's an assertion about a legal question as well as a factual question.
Yes. So
who's an inventor for the purposes of the Patents Act?
Dr. Thaler, it clearly is admirably anxious not to misrepresent his position to the world.
Yes.
And if he were to say, I'm listing myself as the inventor and deviser, but only to the extent that I use this machine and software within my control and asked it to investigate this matter, and it came up with something, that again wouldn't cause the controller to police the matter any further.
And that's also, we'll get to the EPO decision a little later, I hope, but that's also what the EPO suggested. They didn't say you could file an annex like the type of annex. They said you could put a statement like that in the application for a patent to meet the fairness concerns that you've raised in your annex. Namely, it's not fair that Dabus isn't going to get the credit that it deserves.
Well, not that Dabus has any moral rights as
well, that's my position, but my learned friend seeks to assert them. And so they say you could put something in the application.
Yes.
And I say that the place that what they meant there and the appropriate place would be for that to be in the specification. We'd have no objection if they did that.
No. And if that is done, there may be no mechanism under the Act by which that the patent can be revoked on the basis that
well, not for that reason.
Thaler wasn't in fact the deviser.
Not for that reason. I mean, I should say in terms, if it need be said, the controller is not encouraging anybody to lie in their applications for patents.
Yeah.
Absolutely not.
No.
But we say the correct legal position is that the inventor is not the AI. It is a person who actually devised the invention. And if you want to say something else about having used an AI in your specification, which is a public document, which is presented to the world, then so be it.
Yeah. We better let you develop your submissions.
Thank you.
Thank you.
My final point before engaging properly with 13.2a on its terms is that the effect on the rest of patent law is relatively unclear, because pursuant to Section 3 of the Act, which I don't think we need to turn up, an invention is obvious. An invention that is obvious in light of the prior art and common general knowledge is invalid, and that question is addressed through the eyes of a notional skilled person. So imagine if Dr. Thaler were to prevail on this appeal, and then in a given field of endeavour, the great majority of applications, in fact, were then made designating AI inventors. Should not then the relevant skilled person in that field of endeavour for assessing obviousness also be an artificial intelligence? What then would it mean for something to be obvious to a machine? We have all sorts of considerations in our well-developed law about obviousness. It's a mixed an awful lot of factual considerations that go into a multifactorial assessment involving how seriously a given document would be taken, how interested you would be in it in light of prejudices in the field, and so on. How on earth all of that is supposed to be read onto an AI is a very difficult question, to which the controller certainly has no answer. But they serve to illustrate, in my submission, that the changes you're asked by my learned friends to make, or the requirements, perhaps more accurately, that you're invited to overlook, operate very close to some of the central tenets of our patents law scheme. This isn't just solving one problem. This is really close to the fundament of what it is to invent something that's patentable. The final point I want to make on this is that any change, were it to be made, and the controller is open-minded about the fact that changes may need to be made by Parliament in future, at the moment does not appear to be the right time to make any changes, and you've seen in my written submissions the government's response to the consultation, the wide-ranging consultation that we made. This is not about the controller standing here and saying this is an outrageous idea forevermore. Not at all. But when those changes are to be made, they need to be made in an international context because we operate in an internationally cooperative system. Under my paragraphs 49 and 53 of my written submissions, which I don't propose to take you to again, I'll just give you those for your note, I've quoted the parts in particular of the government response to the consultation that highlight that a major concern of the respondents was this really needs to be international. We can't just have one country changing the approach and not the others. And I'll explain why that might be of importance to them. If we were to allow, for example, inventions designating AI as the inventor to proceed as patents in the normal way, and other countries didn't, we were the only country that did it, and that's what would be the effect of a judgment in Dr. Thaler's favour, at least temporarily. The concern is that people would simply stop filing their patents. Multinationals who've got a patent portfolio across several jurisdictions for a given set of inventions would be discouraged from filing in the UK because otherwise they'd have to assert here that they had an AI inventor and then give a statutory declaration in the United States, for example, on pain of imprisonment if it be false, saying that it's not the AI that's the inventor because there it can't be. So for the UK or any other nation to be a tail-wagging an international patents dog is not a very desirable position for industry to find us in. And so that's a further reason why making changes on the basis of an appeal from a single decision of a hearing officer in the UK IPO is not the way in which any change, should there need to be one, ought to be made in my submission.
Well, the appellant is clearly wanting internationally to raise this as an important issue. Is anything going on internationally after the controller's consultation?
As I understand it, the WIPO has a parallel consultation process. Is that still ongoing? Yes, that is still ongoing, which is the World Intellectual Property Organization. So the short answer to your question, my lord, is yes. There is an international conversation, I can put it that high at least.
Thank you.
Is WIPO an intergovernmental organisation, or is it an NGO of some sort? Or?
It's an intergovernmental organisation, yes. That's probably the best way to characterise it. Thank you. I look behind me to check that I'm not saying anything wrong, but that seems to be right.
Thank you.
So to the case under Section 13.2a. I'll deal with this in two parts. First of all, I promise quite briefly now that the inventor must be a person for the purposes of this section particularly. And then secondly, construing the provision as to the consequences of a failure to identify a person as the inventor. I've already done the context showing that moral rights are key, and I say that that suffuses everything. I'm not going to repeat it. It fits also, of course, with Lord Hoffman's comments at paragraph 19 in the Yeda case that I think my Lord Richards put to my learned friends earlier, that section 7.2b provides for the inventor and those claiming through him. The fact that the inventor has always got to be in the mix somehow is because a central part of this system is affording that person their moral right to be mentioned. And we saw that in the 49 Act and the scheme leading to the 77 Act as well. So we shouldn't be surprised when the 77 Act is arranged and drafted in a corresponding way. We'll start with Section 7 and 13 themselves to show that they assume on their words that it's a person, and then I will very quickly show you there are several other instances in the Act that fortify the submission, as Lord Justice Arnold did in the judgment for the majority in the Court of Appeal below that one of my lords referred to earlier this morning. So Section 7 is on page 293. And as we've seen, this goes to who may apply for a patent. Paragraph 1 provides that the applicant must be a person or persons jointly. No controversy about that. As for who qualifies, then, 7.2 provides a closed list of candidates, an exhaustive code, Lord Hoffman said in Yedder. Patent for an invention may be granted primarily to the inventor or joint inventors. B, in preference to the foregoing, to any person or persons who, and for present purposes we'll say, engage a suitable rule of law. And C, in any event, to the successor or successors in title of any person or persons mentioned in paragraphs A or B. So plainly, the things mentioned in A and B are persons as well. And A is the inventor or joint inventors. So the scheme of this section is plain that the inventor is a person or persons. That's a clear and express understanding.
I think the point, I'm sure you will be addressing it, but the real argument against you, I take to be that even though the inventor has to be a person, there doesn't have to be an inventor for somebody to be capable of qualifying under 7.2b.
Well, that's the point that was addressed in paragraph 19 of Yedder by Lord Hoffman. He says the contrary. He says you've got to claim either as the inventor or through the inventor, and I say that a further reason why the Act is arranged that way is the necessity to accommodate the affording of the moral right to be mentioned to the inventor, even if they're not going to have the patent themselves.
Well, but if there is no inventor because it's a machine, then nobody needs to be able to claim the moral right. And so there's no need to afford that opportunity.
That's certainly true, and I say that's the reason why it wasn't provided for in this scheme when this Act was drawn up.
Well, that begs the question, though. What we're concerned with is why it can't come within 7.2b.
Well, because C is clear that the people in A and B are both persons or is a person or person.
Yes, but it'd be a person within 7.2b, but the person would be one who was entitled to the whole of the property in the invention without having invented it.
Sure, but there's the same route.
That would be Dr. Thaler here. He'd say, well, I'm entitled to the output of Dabus, but I am not the inventor of that item. But I can still come within 7.2b, and if I assign my right, then my successor in title will come within 7.2c. What's wrong with that?
What's wrong with that is that this makes clear, and the whole of the scheme as we're looking at now, makes clear that what was being provided for in the 77 Act was inventions by persons. I say it may well be that there's a perfectly good policy argument to say it would be good if Parliament had provided a different scheme which provided for non-persons, but here, just looking at Section 7 locally to itself, and we've seen all the context as well which leads to the need for persons being central to the whole idea of inventorship, here it's clear that A and B are each persons. So
but there's no dispute about that.
Yes.
It's important to be clear that the argument is not simply that it's Dabus claiming under 7.2b. It's Dr. Thaler claiming under 7.2b
right.
on the basis that he owns the property in the output of Dabus.
Yes. Dr.
So why
Thaler
is that what's incoherent about that?
There's nothing incoherent about that as far as it goes. But there are other requirements.
Your point, as I understand it, is that when it speaks about someone entitled to the confidentiality rights and the right to apply for a patent. That the scope of that rule of law has to be seen in the context of the Act as a whole, which you say only allows for a natural person as an inventor.
As the inventor. And I say that that's reflected even in this section because of the way that C is arranged. Absolutely. There's no difficulty with Dr. Thaler being an applicant. The difficulty is that he did not meet the requirements of the Act because he didn't name a human inventor, and that is a requirement on my submission.
Is it part of your case that an invention has to be invented by an inventor?
I prefer to put it this way, my Lord, which is that an application for a patent must be made nominating a person as the inventor, because the reason I reformulate that is because this problem doesn't arise because of something that the controller has determined about the invention. This problem has arisen because the application for the patent was defective because it did not name an inventor, or for 13.2b.
Yes, but I mean, you were starting to draw our attention to provisions that make clear that under the Act, leaving aside 13.2a, an inventor must be a person.
Yes.
So it's perhaps not a big leap from that to say that if you've got that an invention is something created by an inventor.
Yes, that must be, in order to get a
inventor
patent.
under the Act must be a person.
An
Can
inventor.
you have an invention under 7.2b which has not been created by an inventor?
So it won't count as an invention.
I think certainly the way I put it is an invention for which a patent can be granted must have a human inventor.
Yes, well, these are all terms under the Act. I mean, that's
Yes. Yes, of course.
This is a
Yes.
yes, right. Okay, thank you.
So I think the answer to your original question was yes, but I prefer to put it as an invention for which a patent may be granted.
Yeah.
Because it's the process of seeking a patent that has given rise to this problem, not because there was an innate difficulty with the invention
I follow that.
that the controller.
Well, an inventor, as the term is used in the Act, it's got inverted commas around it in 7.3.
Yes.
So I think you have my point on section 7. I simply say that C makes clear that A and B are both persons as well. So to section 13 itself, which is on page 298.
Just wait for me, one other question. Under 7.3 and the meaning of the term inventor,
Yes.
deviser, that includes presumably a person who uses a very sophisticated piece of equipment without which it would not be possible to make the invention.
Yes. In my submission, there are several patents that have been granted on.
Yes.
I mean, begs the question about how sophisticated is very sophisticated, but I would certainly say high throughput screening basis.
High performance computers, modelling, all of these other devices which are used routinely to make inventions or are harnessed to make inventions.
I
Don't exclude that there being an inventor within the meaning of the Act.
No, that's right. So to section 13, and then, if it pleases, I might just list the remaining provisions I was going to go to because I've got a bit of an eye on the time. Section 13(1) provides that the inventor or joint inventors of an invention shall have a right to be mentioned. So you've got my point about that. Again, it's a paternity right corresponding to a person. And then 13.2 and 13.2a requires the applicant to identify the person or persons whom he believes to be the inventor. And then finally, there's 13.3, which begins where a person has been mentioned as sole or joint inventor in pursuance of this section. So it too recognises that anyone mentioned as inventor, anyone availed of that moral right, is clearly a person. My Lord Justice Arnold addressed at paragraph 117 of the judgment below, also section 2.4, sections 8.1 and 8.6 of the Act. With an eye on the time, if it pleases, I propose just to give you those references and to move on.
2481 and
2 sub 4, 8 sub 1 and 8 sub 6.
8 sub 6.
They're all in 117 and following of my Lord Justice Arnold's
recall that.
majority.
Thank you.
So drawing the threads together on the statute, in my submission we've seen that the context of the Act is such that it considered inventors only as persons, the recipient of rights and moral rights, And looking at the scheme of the Act itself, I say it's clear that that's exactly what Parliament provided. And finally, we add to this the words of Lord Hoffman and Yader, which we don't need to go to again, with whom all of their lordships agreed in that case. And at paragraph 20, there's the reference to the inventor being the natural person who came up with the inventive concept that you saw this morning. That's on page 466 of the bundle. I don't propose to go to it now, but just so you have it for your notes.
Thank you.
So as well as the form of the statute and the context of the statute and the international context, there is the highest authority in the case law as well for the idea that the inventor is a person and a natural person at that. And that's a House of Lords decision from which Dr. Thaler hasn't applied for this court to depart.
But the House of Lords weren't considering the possibility that somebody other than a natural person could invent something, were they?
Well, there were certainly corporate bodies involved in the factual matrix of the case. It was not an argument about the type of person. That's absolutely right. But Lord Hoffman did say in terms the natural person who came up with the inventive concept. And I think he was considering the scheme of Section 7 in detail and as a matter of general principle. It wasn't a throwaway remark. It wasn't a remark completely outside of the context of the case. Far from it. It's a statement of principle, and it's one from which Dr. Thaler hasn't applied for this court to depart from itself. So, as all judges below have accepted, including Lord Justice Burse in his dissent, an inventor for the purposes of the patent in my submission must be a person. So then we get to the question of the consequence if a human inventor isn't named, and this goes to the controller's role and some of the questions I was addressing with particularly my Lord Kitchin earlier on. Earlier on, when we looked at the legislative background, I drew an important distinction between checking the veracity of an asserted fact on the one hand and checking the adequacy of that asserted fact when assumed true on the other. That's going to be of central relevance in my submission to this point. In light of the submissions I've already made, identifying the inventor for a patent application necessarily requires identifying a person. But the words of 13.2a, which we must assume have been chosen with some care, make the position clearer still, because it says he must identify the person or persons whom he believes to be the inventor or inventors. Now, as I submitted in writing, there's no inevitability as a matter of syntax about the inclusion of the words person or persons. There are other, more general expressions that Parliament could easily have used. It might perhaps have said identifying his belief as to the identity of the inventor or inventors, or identifying whom he believes the inventor or inventors to be.
But if the purpose of this is to identify any person who may be involved so that they get the credit and the recognition for it, then that purpose will be achieved if provided there is a person, you identify that person, and if there isn't, you say not applicable.
That part of the purpose would be, absolutely, that must be right. But I say that the whole of the scheme didn't afford patent protection for inventions for which there isn't a human inventor, because the purpose is the fulfillment, in part at least, of a moral right, and the machine doesn't have one. So it's common ground that 13.2a of the Act sets out a requirement. That's paragraph 29 of my learned friend's written case. They contend that it's a procedural requirement, which may well be. I say there's nothing in that, but still, he accepts it's a requirement. It's also common ground that Dr. Thaler didn't identify a person or persons, and the statute is clear that this requirement, regardless of whether or not we characterise it as procedural, is one that has a substantive consequence, which is how Lady Justice Elizabeth Lang put it at paragraph 104. If 13.2a is not complied with, then the consequence expressly provided follows as a matter of course. That is, the patent application in question is deemed to be withdrawn, and that's what happened to both in this case. So next, I won't engage directly with this, what I say is an important distinction, which has been elided often by my learned friends, between the veracity and the adequacy of the factual assertions. Dr. Thaler's suggestion is that the changes in the law that led to the 77 Act left the controller with essentially no role at all in looking at what information he's been given for 13.2, and like the majority of the Court of Appeal, the controller disagrees. We do agree, to be clear, that the controller will not go behind the factual veracity of the assertions made. But he does need to look at whether the assertion made, when assumed to be true, is actually adequate in the sense of being an answer to the relevant question. So in the case of 13.2a, that means, has the applicant identified someone who is capable of being the inventor? We accept, again, the controller has no power, indeed, to go behind the fact. He won't investigate whether, in fact, the claim invention was actually devised by that person identified, nor will he examine the electoral roll, as I said earlier, to see if it really is a person that exists. The factual assertion is taken at face value as true.
You want to read 13.2, do you, as saying, in effect, that the applicant must confirm that there is a person whom he believes to be the inventor and identify who that person is?
I suppose that would be right. Yes, I suppose that's right. But by identifying one, you do confirm that there is one, I suppose.
Well, the other way, I mean,
right.
it is at least a way of reading it as a matter of
I don't think I quibble with
ordinary understanding, isn't it? That if you're confronted with a question which assumes something which is false, you can answer it truthfully by pointing that out.
Well, it does say identifying the person.
Yes, and one way of reading it is when you get a question like that, the answer is not applicable, or
but then you haven't
I can't identify it. No, but there are many contexts in which that would be. You don't fail because the question is one that doesn't have an answer.
It might be a morally acceptable position, but it's not what the scheme of the Act provides. You haven't identified a person. Maybe for a jolly good reason, because you say there isn't one. But you
say it's only capable as a matter of English of being read that way, do you? And that you couldn't understand this reasonably as requiring you to identify a person provided there is one?
Well, as a matter purely of linguistics, I'm sure that that's an alternative, yes. But I say in light of the scheme of the Act and all of the things that we've seen in the history, it's not a plausible interpretation of this provision in context. This is providing for person inventors, and so you've got to identify one. And there's a purpose for identifying them, which is that that name can go out in public so that they can fulfill their moral right. So as a matter of linguistics, of course, that's a plausible read. I'm not saying that that's impossible to divine from these words read in isolation, but I say that we're not to read them in isolation, and as soon as they're placed in their proper context, that's not the appropriate interpretation with respect. So the controller does need to ask himself that question: has the applicant identified someone capable of being the inventor? We say that this would be the appropriate and sensible interpretation of this section taken even on its own, because to say that the controller just averts his eyes when an alleged answer is supplied for either A or B that's bad on its face robs the provisions of any force.
That's the key difference, isn't it?
Yes.
I mean, you're saying the Act requires certain things to be stated in the application. If on the face of the application they aren't there, then the Act requires a deemed withdrawal.
Right, and it's no
if
answer.
they are there, the veracity of those answers is not a matter for the controller.
Yes, and if they're not there, it's no answer to say, but there's some ink on the page. Section 15A in my submission makes this clearer still. That's 15 capital A, which is on page 299. Makes it clearer still that the controller does need to look. So this model put forward by Dr. Thaler, the sort of unthinking recipient, a conduit for information, doesn't question it, doesn't query it in any way at all, just doesn't fit with the statutory scheme. So section 15A is on that page. Sub 2, on a preliminary examination of an application, the examiner shall determine whether the application complies with those requirements of this Act and the rules which are designated and so on, and B, determine whether any requirements under section 13.2 or 15.10 above remain to be complied with. I would also draw attention in particular, I rely on all of this section, but particularly then subsection 9, if a report is made to the controller under subsection 3 above that any requirement of section 13.2 or 15.10 above has not been complied with, then the controller shall notify the applicant accordingly. So the judgment of Lord Justice Birth in dissent below was that the legislative history simplified things to the extent of giving the controller no effective role, that he was not to look anymore at the information he was given, he was just to publish it with his eyes shut, and the public would take care of any errors. In my submission, that's not correct, and it doesn't fit with what section 15A mandates, and it is in mandatory terms that we shall determine whether 13.2 has been complied with. Now, the compliance is by identifying someone, in the case of 13.2a, and so it's true that we don't go behind the factual veracity. I've made that point many times and I won't labour it again. But we do have to look and see and determine whether 13.2 has been complied with. So this unthinking publication of information without looking at it is just not, in my submission, correct. It doesn't meet the command of section 15A because it would involve no determination whatsoever. There's another example of exactly this distinction, looking at the adequacy but not the veracity of an assertion in the case law, and slightly mysteriously it's cited with approval by Lord Justice Birth. It was discussed in the judgment of the Patents Court, Mr. Justice Whitford, on appeal from the office in the Nippon Piston Ring case. In fact, it goes to 13.2b, so we may consider it later again under that head, but the logic is exactly the same on this distinction between adequacy and veracity, so I'll deal with it now. For your note, Nippon Piston Ring itself is at page 436 of the bundle, but for present purposes we can take it from Lord Justice Birth's treatment of it in the Court of Appeal judgment. You don't need to read it all. So it's paragraph 62 to 64 and then 69. Not because I don't want you to read at some point the things in between. I'm not seeking to avoid them, but for present purposes we can just focus on 62 to 64 and then 69. So if I could ask you to read those, it's probably quicker than me reading them out. It's on page 84, excuse me, I should have told you that. So in paragraph 69, we see that the example is taken from the one the hearing officer gave in the Nippon Piston Ring case as an example of something that couldn't satisfy the requirement to indicate the derivation of right. And the example was where the applicant C said, by assignment from A to B. It would appear that everybody agrees, Lord Justice Birth included, that that was a defective indication, and it's important to consider why. It's not defective because the controller has investigated and found that there is in fact no such assignment, nor that the assignment is bad in law in some way, nor that it in fact is not between A and B. Again, the asserted fact that there is an assignment from A to B is taken to be true. The reason this is a defective indication is because even taking the fact as true, it could never be a satisfactory answer to the relevant statutory question. An assignment to somebody else, B, could never be the derivation of C's right to apply. We say it's exactly analogous here. On 13.2a, the statute requires the applicant to identify the person or persons whom he believes to be the inventor. Naming a non-person could never be an answer, a proper answer to that question. And so without questioning the truth of any assertion made by the applicant, which we've not done and won't do, the controller in such a case must determine, I take that word from section 15a, that section 13.2a has not been met. So there is a role for the controller to ask, has the section been met, that Lord Justice Burst, contrary to what the rest of his judgment says, appears there to recognise. So the way that this is sought to be got around is to rely on the reference to indicating whom the applicant believes to be the inventor. The controller submits that's there to account for bona fide mistakes, as the majority found in the Court of Appeal, and you will recall that part of the Banks Committee report that referred, in particular, I think it was paragraph 528, referred in particular to bona fide mistakes, previously leading to the patent being revoked. And they wanted to get rid of that. So they wanted to make sure that bona fide mistakes weren't a problem anymore. And I say the words believes to be are there for that reason. So if, for example, the applicant by innocent mistake identifies Miss Jones when in fact the actual deviser was Miss Smith, the patent application doesn't suddenly get extinguished or revoked or something. Instead, the mechanisms set out in the Act can be used to mention and or entitle the correct inventor. Dr. Thaler's contention, rejected by the majority and by the judge, but accepted by Lord Justice Burst, is that since 13.2a says what he must indicate is just whom he believes, well, the person or persons, rather, whom he believes to be the inventor, mere subjective belief is enough, and so, he says, that eliminates any meaningful role for the controller at all, provided there is some ink on the page. I've given you some of the reasons why that doesn't work already, but there are several problems particular to this suggestion. First, the provision itself combines two express requirements: that the thing that's identified be a person or persons, and that it be whom he believes to be the inventor. So a non-person, the subject of a subjective belief, simply doesn't meet that double requirement. Second, thinking about it practically, and Parliament, of course, having passed these provisions fully in the knowledge and intention that they'll be applied day to day by the office and the examiners and hearing officers of the office, this in effect would displace a very simple inquiry: has the applicant named what appears to be a person, in favour of an extremely burdensome and indeed near impossible one, namely, does the applicant genuinely believe, subjectively, that who or what he has identified is the inventor? This difficulty is illustrated by part of Lord Justice Burst's reasoning. If I could ask you to read paragraph 60, and only that paragraph I need for this. That's on page 84. So to illustrate part of the problem, this goes to some of the questions my Lord Kitchin put to me earlier about colourful examples. If an inventor in his heart of hearts, as Lord Justice Arnold put it before me in the Court of Appeal, really believes that his cat Felix invented the invention for which a patent is sought, and indicates my cat Felix for the purposes of section 13.2a, On Lord Justice Burse's interpretation of Section 13, the controller is empowered to do nothing but shrug. The logical difficulty, though, becomes clear from the third sentence of that paragraph of his, where he says, if the statement of inventorship which was filed gave a silly reason why the applicant was not able to name a person who was the inventor, then the controller would be perfectly entitled to be suspicious. My lords, I say with respect, the problems with this paragraph are many. First, what is the yardstick for determining what is a sufficiently silly reason why a personal inventor couldn't be named? As to this, Lord Justice Burse offers nothing. And if this sort of approach is to be endorsed, then I must, without any hint of facetiousness, ask, on behalf of the examiners and hearing officers whom I represent, that if this court is going to follow that line, then please to offer in your judgment detailed guidance about how these yardsticks are to be applied day to day.
Paragraph 60 is just incapable of fitting with the language of A.
And also,
you can't name a cat as a person. No. It's not name something which the applicant believes to be a person, believes A to be a person and B to be the inventor. You've got to identify a person.
That's absolutely right.
And it just falls.
Paragraph 60 just cannot.
I mean, you could have these problems. I don't see it's a problem in itself the way he's approaching it. If somebody put down as the inventor Donald Trump or something, then the controller might have to be satisfied that that was their genuine belief, mightn't he? Or he might be suspicious and want to check whether it was.
Well, he's entitled to be suspicious whenever he wants to be suspicious, yes. But the Act doesn't empower him to do anything but accept the naming of a person.
Well, even if he knows it to be false?
Well, I don't think he does know it to be false in that situation. He might strongly suspect it to be false, but if it's asserted that it's false, that's completely different. But as in this case, where it says we're not naming a person, that's a different set of...
I'm just thinking of whether he's never exercises any judgment at all.
No, you can't... there's no power for the controller to say that doesn't seem very likely, or I happen to know this person's only 6 months old, or anything like that. No, we don't go behind the factual veracity of the statement that the actual deviser is the named person. What we do examine is the adequacy of the answer. Is it a person so that it can fulfill, could be an answer to Section 13.2? But my point, I absolutely endorse what you've said, Lord Richards. That's absolutely right. Paragraph 60 just cannot be right. Simply cannot fit with either the Act or any workable model of how the IPO is supposed to operate.
Yes. I mean, I'm not sure that Dr. Thaler really supports it, because the way he puts his case is that it's enough to say no person, rather than put in life.
Well, yes, but part of the reason why they say that is they say that it's enough because it's our subjective belief.
Well, they assert it's no person. They say that's a sufficient answer to what's required by 13.2a. I don't think they're really endorsing paragraphs.
Well, not paragraph 60, but they do rely, as I understand it, and they certainly have in writing, they do say, and it's enough because it is our subjective belief. It is Dr. Thaler's subjective belief.
Well, I understand that.
And that's what paragraph 60 is going to.
Yes, but, all right. Yep. So your point is that there's nothing, the subjective belief does not go to the person, it goes to the inventor. That's
absolutely, absolutely right. So later in the paragraph, Lord Justice Burse then states there's no reason to read the section as imposing any higher obligation on an applicant than to state their genuine belief about who the inventor was. But of course that neatly crosses out the words that Parliament chose to add in, which is that they should indicate the person or persons whom they believe to be the inventor or inventors. But I say it's more serious than that, because the one thing that this model, saying, well, because it says believes to be, anything goes, the one thing it does leave the controller to check is the one thing he can't possibly check. So in truth, I say this passage just serves to illustrate that this just don't look approach, saying that the controller's role after the Banks Committee report and in the 77 Act was reduced to simply checking there is ink on the page, has the potential to produce highly problematic results and nothing that could be done about them. Instead of a simple test of could this, if true, be an answer to the relevant question, it substitutes an impossible inquiry. So you have my submissions as to the proper interpretation on 13.2a and what section 15, capital A, require. In this case, that's exactly the approach the controller took. He didn't question the veracity of the statement that Dabus created the inventions, and to be absolutely clear, he still does not question that assertion. What I did say in writing, and I stand by, is, of course, we must have in mind that this case is proceeding only on an assumption. That assertion has never been tested by anybody. It appears to be controversial, but this appeal proceeds on the basis it is true. But when it comes to making arguments based on policy and urging on my lords to change the law, assumed facts that won't ever be tested for the basis of an inquiry that will always proceed on assumed facts, is a pretty unhappy basis for policy making. So that was the only reason to refer to that. We don't go behind, for present purposes, the assertion that Dabus created the inventions is true. So the inevitable consequence was that the two patent applications were deemed withdrawn as the section requires. I was, before turning to 13.2b, going to go through the decision of the legal board in the EPO. With an eye on the time, I might invert those and do section 13.2b first, if it pleases, and then, if I have a little time at the end, just very quickly take you through. I want to do the EPO decision with a bit of care if there is time, because I regret to say there are certain aspects of it you were taken to, and you were told about statements of the legal board and things the legal board had said, which in fact were not things the legal board had said, but were the legal board characterising arguments that they then went on to dismiss. So that's not going to be a super quick job, I'm afraid, in light of the submissions made this morning. But I'll deal with section 13.2b first, if I may. Of course, if the controller and each of the three tribunals below are right about 13.2a, then the point on 13.2b doesn't strictly arise, because either of these reasons for the deemed withdrawals is independently fatal. Of course, I will deal with 13.2b as well, though I do hope I'll be able to take some of it rather more quickly in light of the things I've said to you about paragraph A. The overall shape of the argument is indeed similar, and we say that in providing the answer by ownership of the creativity machine Dabus, Dr. Thaler didn't identify the derivation of his right to be granted the patents, which he was required to do. I note as well in passing that my learned friend Professor Abbott this morning took you to a suggestion in the Nippon piston ring case that said all you have to do, it was put this morning, is say which of 7.2a, b or c you rely on. I would note that that was not done on the Form 7. The Form 7 just says by ownership of the creativity machine Dabus. There was no reference to any of paragraphs A, B or C. But this is another instance where my veracity versus adequacy distinction is important, and my points on that are exactly analogous to the ones I've already made, so I won't make them again, and we've already seen the example that Lord Justice Burse, for reasons I can't help you with, accepted that the assignment from B to C couldn't help A. That was an example under 13.2b. Instead, here, for the 13.2b point on this appeal, the central question is whether, in fact, the asserted fact that Dr. Thaler owns Dabus is indeed adequate as a derivation of his right to be granted the patent. My lords will recall that 7.2 is an exhaustive code comprising the three categories of persons who may be granted a patent. And you're aware that it's only B, the rule of law portion, if I can put it that way, upon which Dr. Thaler relies. So the question for present purposes boils down to whether there is a rule of law that rendered Dr. Thaler entitled to the whole of the property of the invention other than equitable interests at the time of making that invention, and the controller submits there is not. Dr. Thaler relies principally upon the common law doctrine of accession as the rule of law, and I accept, as Dr. Thaler has contended in writing, that it doesn't matter if the relevant rule of law isn't provided by the Act itself. I think that's obvious, but it was a point that was raised in writing, so to be completely clear, I accept that. A rule of law extrinsic to the Act would suffice. We do, though, disagree with Lord Justice Burse's suggestion, which I don't think we need to turn up, but for your note, it's at paragraph 97, that it doesn't matter if there is no extant rule of law, the court can just make one and it will retrospectively qualify for the purposes of section 13(2)(b). We say that as a matter of the proper interpretation of 13(2)(b), there must be an extant rule that operates to entitle the applicant to, I won't repeat the wording again, you know what it is, and that's for essentially to all of the property in the invention at the right time. That's for essentially two reasons. First, it's important to bear in mind that Section 13 is, and always was intended to be, a provision that the UK IPO for its controller has to apply day to day. So it's the examiners and hearing officers, and not lawyers, still less judges, who are going to be applying this provision administratively in the ordinary course. An interpretation of Section 13 that requires those people to divine not just what relevant legal rules exist, but any others that might in due course be created, isn't a reasonable burden to suppose that Parliament intended to place on my colleagues at the office. Second, perhaps more fundamentally, the central difficulty with such an interpretation is that it's basically boundless. To say that a person must indicate that he falls within a set of rules, or within any other such rule as might ever be created, imposes no real requirement at all.
Where did Lord Justice Burst do this? Gave us?
It's paragraph 91 on page 90. He deals with this very swiftly and in passing because on his view it doesn't arise, of course.
Well, I mean, what he said is, for what it's worth, I do not see an unsurmountable barrier preventing the court from finding that there is a rule of law. In a way, that's how the common law works, isn't it? We sort of discover the truth that has always been there but has previously been hidden.
Well, that's right, yes. And the common law is about stating what the law always was.
So, I mean, if there were, Dr. Thaler could assert
yes.
a rule of law which had not previously been
and so I don't, for example, say that the doctrine of accession doesn't apply here.
Well, there might be something else, but it's never been explored in the authorities, but this court said it existed and applied. And that would mean that it was a valid application. I mean,
it may never have been elucidated, but it must already have existed.
Yeah. Mm.
That's my central point. I certainly don't say that the precise factual matrix or an exactly analogous one must already have been considered by the court. That's not my submission at all. But I do say it has to be an extant rule of law.
Yes, well, I follow that.
And the doctrine of accession clearly is one. The question is whether it applies to Dr. Thaler's case so as to entitle him to the whole of the property in the invention. In my submission, not, for essentially three reasons. First, in my submission, Lord Justice Arnold was correct to find there is no rule that the owner of some tangible property owns any intangible property that it generates. Second, there are specific examples in the law of intellectual property that show that the doctrine of accession doesn't operate here, so as to give the owner of the thing the status of also being the owner of the IP fruits of that thing. I'll take you to these specific examples in a moment. And third, I'll say that in any case, the process of invention understood from the scheme of the 77 Act is fundamentally and materially different from the processes of secondary property generation to which the doctrine of accession has been and can be applied. Briefly and with regret, we need to deal with the nature of what the whole of the property in the invention is. Lord Justice Arnold found at 128, there was a suggestion earlier that he found there was no property in the invention because it was information and that was the end of it. That's not right. Lord Justice Arnold found at 128 that it was the inchoate right, and it was a right to apply for or be granted the patent. That, incidentally, is also the heading to Section 7 of the Patents Act 77. If you turn that up on page 293, the heading to section 7 is right to apply for and obtain a patent. In my
Well, that's rather a circular explanation, isn't it? If the person who has the right to apply for a patent is the person who has the right, who owns the property, and that means the right to be granted the patent.
Well, it's whom can you be granted the patent to? It's primarily the inventor, and then the person who had the right to apply for it and obtain it because of operation of some rule of law. I think that's not so much circular as just perhaps obvious.
All right, well, what's...
So I say that the nature of the property right is it's the right to apply for and then be granted, all being well, the patent. And it's inchoate. I think Lord Walker in Yedda characterised it as a caterpillar that may or may not become a butterfly. And the shape of its wings will be determined by the specification and the claims, which may be adjusted through the examination process in the proper way. So it's inchoate in the sense that the boundary of the property right, in a sense, is not fixed at that time, because the patent itself, the application for the patent and the patent will define that property later, but the right to apply for it is the relevant property right. And I understood what Lord Justice Arnold to say, and I submit, that the point is that there is no other property beyond that that counts for this purpose.
So you have to identify a rule of law which gave you, at the time of making the invention, the right to apply for a patent.
And when my learned friend Professor Abbott was dealing earlier with notions of what the invention would be and what could be assigned and so on, really all the examples came back to, well, assigning the right to apply for the patent, which must include the right not to, incidentally, as well.
Do you accept that can be done?
Of course.
Yeah.
Of course. So the first step is, the Lord Justice Arnold was correct, an invention is a piece of information. That was stated in terms in Merrill-Dow and the unanimous committee. In that case, that's page 418 of the bundle for your note. And the crucial quote is on page 428, but it's a standalone sentence which says only that, so we need not turn it up. There's been no application to reverse that prior authority either. But my learned friends instead seek to put a gloss on it and say it's only sometimes true. They take up the suggestion from Lord Justice Burst that instead sometimes the invention may be a product. And they rely on section 60, the infringement provision, which is at page
I wonder if,
315.
I mean, you may be shooting at a target here which doesn't really exist, because all Lord Justice Burst, I would imagine, was saying, was somebody well versed in this, is that a product is a manifestation of what may be the outcome of a patent.
I mean, that may be what he meant.
Maybe a process.
It's not what he said. He said the invention isn't necessarily information. Look, it can be a product. But in the context of 60 sub 1a, that's just wrong, I'm afraid.
Information about a product,
Precisely.
about how to make a product.
Precisely, because there's no requirement at all that the physical product exist to apply for the patent. There's no room for an argument that, well, you never made it, so there's no property, so there's no invention, so there's no inventor, and you can't apply. It's nonsense. This is just a shorthand in the Act, where it says where the invention is a product. It means where the invention is the information about a product, or where the invention is the idea of a product. I mean, it becomes even clearer under 61b, where the invention is a process. I don't even know what it would mean to say you own a process separately of owning the information about how to work that process. So I'm afraid that statement that's been taken up in writing by my learned friends from the dissent just isn't right. So an invention is information, and accepting fully what my Lord Legate said earlier on about how what you characterise as property might be a bit of an arid labelling exercise at some level, the law doesn't typically recognise property and information, and so to that extent, for example, an action for breach of confidence isn't typically understood or expressed as the claimant having property in the information per se. It's, of course, an equitable right right in breach of confidence, to proceed to restrain the unconscionable breach.
Well,
It's not about owning information that you want, it's not about owning a property that you want to get back.
I hesitate to interrupt again, but is this a little bit of an arid dispute? Because you accept that it can be assigned, you accept it's information about a product or a process. The person who is entitled to it may or may not put it into practice, may or may not file a patent application for it. Obviously, they can't do both. They can't keep it secret and apply and hope to get patent protection, because that's the patent bargain you mentioned earlier.
With respect, I'm not sure the "it" in all of those sentences was the same. So what I accept is that what can be assigned is the right to apply for or be granted the patent, and that is the property with which you're concerned for the purposes of 7.2b. And the point that's being dealt with here is that such other property as might be alleged to exist would only be information, and we don't typically treat that as property. I'm just trying to fortify the submission.
That exists quite apart from the Patents Act.
Well, that's
confidentiality in the information would exist anyway.
I'm just trying to...
There weren't a Patents Act. So
quite so.
rather supports the view that it's the right to apply, which is really what the Act is
absolutely so
driving at.
And what it says in terms is what it's driving at, as the header to that section. I'm just trying to... I have to deal with the submissions that have been made and say, I don't think there's anything else here. That really is the property right. It's the one that Lord Walker identified as Lord Justice Arnold says. So he starts with this analysis about information, going on a search for any other property, and the end point of that analysis is not, therefore there isn't any, which is how it was presented to you slightly this morning, but is to say it's the inchoate right, as Lord Walker identified, that's the right to apply and be granted. I can skip over that in that case. No rules about intangibles created by tangibles. My Lords, perhaps you can just read this from Lord Justice Arnold, because I embrace his analysis on this point in full. It's on page 100 to 102, paragraphs 130 to 137. And if I could ask you to read that, then I can make some very short submissions about it.
Which paragraphs you want us to read?
Sorry, it's paragraphs 130, beginning the rule of law, down to 137.
Thank you.
So I propose just to draw out what I say are the key points from that, but I embrace that analysis that you've just read in full. First, I say it is telling, though not determinative, that the appellants have not been able to point to a single case where the doctrine of accession has been said to apply to the generation of an intangible by a tangible. Indeed, even Blackstone, in the texts that have been put forward by the appellant, hadn't proposed such a situation, even though he had intangible property well in mind. And indeed, the reasoning set out in the passage from Blackstone upon which they relied, and quoted by Lord Justice Arnold there, doesn't read across to the present appeal. And the reason for that is that intangible property can be possessed and or consumed by multiple parties at once. In Lord Justice Arnold's language, intangible property is non-rivalrous. So that's one complete reason in my submission for which the doctrine of accession can't be applied to ownership of Dabas and its inventions. I also said that I would show you that the doctrine specifically doesn't apply in other examples in the intellectual property context. One of those I submitted in the Court of Appeal, and you've just read in Lord Justice Arnold's judgment there, comes from the law of copyright. And I noted in writing as well, under the provisions of the Copyright Designs and Patents Act 1988, the owner of a camera does not generally own the intellectual property in the photographs that are its fruit. That would instead tend to belong to the person arranging and taking the photograph. That was paragraph 135 in the section that you've just read. So the doctrine of accession certainly doesn't apply generally so as to include intellectual property situations to machines that produce works comprising intellectual property. Third, and perhaps a bit more fundamentally, I say that the process of invention just isn't analogous to the situations that accession covers. It's not essentially a form of accession. The doctrine of accession itself includes a fusion of Roman law doctrines, as no doubt you all know better than I, including at least specificatio, which was the transformation of personal property by some other person's labour, and accessio, which was the joinder of two persons' personal property into a single item. But it may range a little wider, including, for example, the doctrine of accretion, includes cases like land that's augmented by alluvial formation, so your island effectively grows by deposits from in the water. And that's the sort of the bit, as I understand it, of accession that's probably most relied on here, though it's never quite been put that way. So the classic examples, the ones I have written down here, are exactly the ones that Professor Abbott enumerated earlier. The owner of an apple tree owning its apples, the owner of a cow owning its calves, and the owner of the island that grows owning the resulting extension. They're all about the property, the thing, being added to so that there is more of that thing. Another way that it's sometimes expressed in the texts is that the relationship between the progenitor property and the progeny is close, so close, in such a way that the progeny are defined by the parent. That sounds a bit obscure, but I mean, the fruit of an apple tree is by definition an apple. The child of a cow is definitionally a calf. The fruit of an inventor's mind is not necessarily an invention that can be the subject of a patent within the 1977 Act. That's not so regardless of the nature of the inventor. Here, the identity of the progenitor, the inventor, is not definitive of the nature of the progeny. By contrast with all those examples of the property growing more of itself, the process of invention necessarily requires something extrinsic to just being an inventor. The Act explains how it requires a process of thought that comprises an inventive step, as we've already seen. So if someone, or indeed something, who is capable of being an inventor produces an idea, that idea may or may not comprise an invention. And the Patents Act is absolutely plain that there are extra ingredients.
Sorry, one has to be awfully careful about this, doesn't one? Because inventions may be generated in all sorts of different ways.
Yeah.
I mean, some are even natural products, which are then recognised by people who find them.
Yes.
New antibiotics, for example.
Yes.
I mean, they're not made by the human being. When they're first identified.
But their status of being an invention doesn't just derive from their coming from the inventor. That's the point. Accession means what it says. We all have an ordinary understanding of what accession means.
I'm sorry, I was just stepping back a little bit from this notion of accession, and it may all come back to the question of is Dabus an inventor within the meaning of the Act? But the notion that you can't have an invention because it's been created or largely or significantly created by a machine or by nature or by accident doesn't prevent it from being an invention within the meaning of the Act. Because it may be recognised by a person who can properly put themselves forward as an inventor.
I see. Yes, no, that's right. Sorry, I understand now. And
it's not generally in the public domain. They identify it, they find it's useful, and
that's right.
they confirm it's useful, and they can put it into practical application.
Yes.
One can secure a patent entirely properly for that, subject to certain exceptions.
Yes. But the rule of law with which I have to engage, the one that's put forward,
is that this is the inventor, and in some way you're acquiring the rights from the inventor.
Because this is the inventor, everything it does is the invention.
I understand.
And because I own the inventor, I own the inventions. And I say the reason that doesn't work is because the relationship between inventor and inventions is not automatic, is not definitional in the same way. It's not a true accession in the ordinary sense of what that word means.
And I understand your submission. Thank you.
So I have to engage with the rule of law that's been put forward, and I say it doesn't apply to these facts because the very nature of accession is that it's the parent that defines the children, and that's why you own them both. And that's not true of invention, and the whole scheme of the Patents Act is about saying invention is something special. So that deals with the doctrine of accession. First exclusive possession, as I understand, so the cases relied on were all in the context of real property, and so the same submission about not applying in any context of a tangible producing an intangible applies here.
Presumably Lord Justice Arnold's categorisation of non-rivalrous would apply here.
Yes. And indeed, if information, just information that is known by someone or something, is the property, then the first possession isn't strictly by Dr. Thaler, but by Dabus. It might be that the first possession by someone who can have a property right was by Dr. Thaler, but it wouldn't be right to say that Dr. Thaler was the first. Now, my position is, as you've already heard, this is not the right property right. This is not the one we're concerned with. But even on their theory, I don't think actually that first possession necessarily fits as an account of their facts, even quite aside from the non-rivalrous problem. So I don't think I can see that first exclusive possession works either. Finally, rights in confidential information, which we heard about for the first time today as the alleged rule of law in the hearing on the third appeal in this case. Again, I say that's not really a property right in the sense that the Act is contemplating the relevant right. The Act is concerned with the right to apply for and be granted the patent. That's the property that's got to be transferred. And I don't understand how an asserted right for an equitable action for breach of confidential information is said to transfer the property in being able to apply from one party to another. I don't think that's a mission.
Well, you couldn't assign the right to apply for a patent unless you agreed to keep it confidential.
I'm not sure.
The assignor.
Well, but what you're keeping confidential then isn't the right to apply.
No,
it's the information. Yeah, absolutely. But that's not the property right we're concerned with. That's exactly Lord Justice Arnold's point. Is there are two candidates here. Either it's the information, which isn't the property right, or it's the property right, which isn't the thing which is confidential.
Well, to some extent, they go hand in hand, don't they?
Well, they're related, but I'm not sure. The Act is clear about the property right in my submission, and you've heard my submission as to what it is.
Yep.
But the equitable, I'm not an equity lawyer, but the equitable right is to enforce an obligation of confidence.
Yes.
Yes. And there's no property element in that, is there?
And that's exactly my submission.
Yes.
No.
I mean, it's not. It may involve the protection of information.
Yes.
Which
There's
is
no property right there.
But the right is to uphold the obligation of confidence.
Yes. To stop the unconscionable use of the confidential information. Yeah.
Yeah. You talk about confidential information. I'm just splitting the two.
Sorry, no, you're absolutely right. Yeah, that's the right thing to do, and I'm perhaps highlighting things I shouldn't.
Because the obligation doesn't give rise to a property right in the information.
No. So none of those three candidates in my submission works. And none of them is a rule of law that would transmit simply by virtue of the one stated fact that Dr. Thaler owns the creativity machine Dubbers.
It does all depend, though, on what you characterise as property rights and.
Well, it does,
But your point is we don't need to have that philosophical discussion because in the context of the Act,
you know which
the
property right
that
you're talking about.
matters is the right to
Right.
apply for the patent.
And that's I tried to acknowledge the point that you made earlier on, my lord, that we are dancing on the head of a pin sometimes when it comes to saying, is this property or is it something like property? At some level, it doesn't really matter because we know which property right. We're not casting around for some property right. We know which property right, and we're just asking, is there a rule of law that transfers it? You've been offered three candidates, and I say none of them works. So that concludes my submissions on section 13.2b. I did say I was about 5 or 10 minutes late getting on my feet, so I hope if I can trespass maybe 5 minutes over, that will probably give me time to deal with the EPO decision.
So you have 5 minutes of the appellant's reply time.
Thank you very much. So the decision is in the second bundle. So it's at page 485 and following. I'm afraid there are parts of this where I will just tell you what it goes to and invite my lords to look at it in due course, because there is quite a lot of it here, and if I just read it all out to you, we'll be here for a long time. But what I do want to try and convey is a sense of the anatomy of this decision, because I think there has been some confusion this morning, and indeed in the written submissions, which express reliance on something that's actually an account of a conceived counter-argument that's dismissed.
I think it was apparent by the end of the time we looked at this morning that there was a series of objections which were being set out, which were then rejected.
Yes. Well, and one of those is the one that's relied upon by my learned friends in writing, which wasn't covered this morning. So I just do want to be clear what's going where. So at the beginning, starting on page 486, we have the summary of the facts and submissions. So I don't propose to go through those in any detail because certainly the facts are materially the same, as my learned friend told you this morning quite rightly. Then there's the usual procedural account of when the oral proceedings took place and so on, and the listing of the grounds of appeal. The one thing I would highlight, there's a procedure before the boards of the EPO where a referral can be made to the enlarged Board of Appeal. And the enlarged Board of Appeal is composed of members of the judiciaries of several of the signatory countries. And this operates in this context a little bit like the CJEU used to operate for us, in the manner of a sort of judicial helpline giving answers to specific questions that are asked of it in order to dispose of cases before the tribunal. So, as well as making their submissions on this appeal, additionally or in the alternative, my learned friends invited the EPO to make a referral to the enlarged Board of Appeal. So both of those things were refused, but that's an important distinction to explain the significance of that, because certain parts of the decision go to the merits of this appeal, and certain parts of it go to, and should we make a referral to ask these questions, do we need to know? And as you can imagine, I'll show you the analogue of the Act-Clare test. There's a different test for who should win in the instant appeal and what is an issue that should be referred. So then, starting on paragraph Roman 14 on 492 is an account of the appellant's arguments. Those are perfectly properly all relatively familiar now. Then, section 15 begins at the bottom of 495, and those are the comments of the President of the European Patent Office, who was invited to comment on what the approach should be. There was then a short account that there had been some third-party submissions in Roman 16, a little way down on page 498, but for reasons that are later explained, they didn't feel the need to take account of those. So the reasons for the decision, the operative judgment in this case, start halfway down 498. It's a slightly unhelpful hierarchy of numbering to these paragraphs, but this is all the decision on the merits up until paragraph 4.4.2, which is on page 509. I'm going to highlight some bits of that, but I just want to show you that that's the bit, that's the meat of the decision on the merits in this case. The issues are characterised on page 500. The requests filed by the applicant raise 3 issues, 1, 2 and 3. So those are there on page 500. The first is whether the applicant can designate an entity which is not a natural person as the inventor. The second concerns the statement on the origin of the right to the European patent. Is it enough for an applicant to file any declaration irrespective of its contents, or does the latter need to satisfy specific requirements? And then finally, and relatedly, the role of the EPO and whether and to what extent the EPO can examine and object to statements filed under Article 81 is relevant for both. So there's a familiar architecture to those issues as well. They then discuss the legal framework, and in particular Article 81, which I took you to earlier, and then Article 60 sub 1, which we also saw. Talk about the standalone substantive provision that fulfills 3 functions. I say this is all instructive because the purposes behind the EPC, it is a different instrument, and the decision that my lords will reach is of course a decision based on the Act in force here. But it is, for the reasons that all the judges in the Court of Appeal agreed, generally desirable that we be in step with our EPC colleagues, unless there's a jolly good reason not to be. And for that reason, lots of the provisions, even the ones that aren't specifically called out in section 130 sub 7, are framed in materially similar respect. I put it no higher than that. At the end of, halfway down page 504, at the end of 4.2.2, in view of the normative link between Article 61 and Article 81 EPC, and I understand that to be a reference to the moral rights component, not just any declaration, irrespective of content, can be considered to comply with the EPC. So they're disagreeing with the view of the world that as long as there's some ink on the page, the EPC analogue of the controller can't look. Then they get into the role of the EPO, and I would ask you to make a particularly firm mark next to 4.2.3, because I say this is exactly analogous to the argument I make here, that I've characterised as the adequacy, not veracity role. So it says, in the board's view, it's meant that in the case of the designation of the inventor, the EPO must check whether the request for grant or the separate statement identifies an inventor within the meaning of the EPC. And where the applicant is not the inventor, it must also examine whether the statement filed under the second sentence identifies an origin for the right, which falls within the scope of Article 61. So that's exactly my adequacy, not veracity point. Examination is only a formal assessment. There's a lot been said about this distinction between procedural and substantive, but it just doesn't really go any. There are plenty of procedural requirements that can be fatal if they're not met. An applicant refuses to pay any fees. then the patent won't proceed. But that's not because fee payment has been elevated to a substantive requirement of patentability, nor is that a requirement that's disallowed by the language of Article 52 that my learned friend took you to, which said that inventions shall be granted in cases where they meet the patentability requirements. Clearly not a mandate without more. There are other procedural requirements that can be placed. .3.3 on 507, the top of 507, the purpose of the provisions dealing with the inventor and its designation is primarily to confer and protect rights of the inventor. So it's to identify a legal basis for entitlement and to protect the rights of the inventor. Designating a machine without legal capacity can serve neither of these purposes. That fits with the central submission I made earlier on, well, starting from the very beginning with the history, that the moral rights of the inventor, I said to you that they had a continental genesis, and here it is writ large. That's absolutely central for the EPC. That's what this is for. That's why you need to know who the actual deviser is. And that's why the inventor has to be a person. Then it rejects the further policy arguments at 4.3.5. 4.3.6, there's no normative basis for the alleged right of the public to know who the inventor is and how the invention was made. This is a point I made to you in the UK context as well. That our Act does provide for the rights of the inventor, doesn't provide for the right of the public to know who did it. And then 4.3.8 is the dispositive paragraph. And it's worth emphasising these applications did not proceed. This appeal failed in the EPO. This morning could have been forgiven for understanding the opposite, but all these arguments were rejected. All the arguments, put forward by Dr. Thaler were materially rejected. They were decided against. Then comes the auxiliary request. That was where they filed a separate Form 7 equivalent, I'm afraid I don't remember the form number in the EPO, with a little more information on it, but not changing anything that's material for your purposes. And at the important part here at the end of 4.4.1 is the first full paragraph on 509, where inventor and applicant differ, however, a statement on the origin of rights is necessary under Article 81.2. This provision remains applicable whether the invention was made by a person or by a device. And then at the end of 4.4.2, for this reason, the auxiliary request does not comply and is not allowable. So the alternative argument, which is all the auxiliary request really means, was also rejected. Then comes the question, starting at 4.5, referral to the enlarged Board of Appeal. Do we need to refer some questions to dispose of this? Well, since we've had the punchline already, you can rather guess what the answer was. And they explain in relatively short order, over onto 510, page 510, why they didn't feel the need. So they didn't make a reference. Then comes section 4.6, and a lot of reliance was placed on this. But 4.6 is saying, look at 4.6.1, if it pleases, on page 510. There are two conceivable objections to the board's conclusions on the auxiliary request and the request for a referral. So they've already decided that those are being rejected. The appeal has already failed in its entirety. While we're here, for completeness, there are two conceivable objections that we should probably deal with. The first is set out at 4.6.2, and the second is set out at 4.6.3. The text towards the bottom of 4.6.3 on page 511, it would be disproportionate to deny protection to patentable subject matter for failing to fulfil such a formal requirement. That was relied upon in writing by my learned friends as a statement of the Legal Board of Appeal. It is not a statement of the Legal Board of Appeal. It's their formulation of a conceivable objection which they dismiss, having already disposed of the appeal. Paragraph 4.6.5 on page 512 dismisses those objections as well. It says, well, those are the conceivable objections we can come up with from Dr. Thaler's submissions, reformulated a bit for clarity, they say. These are the two conceivable objections, but they don't succeed. And so at 4.6.7, you see, for these reasons, the board didn't consider it necessary either to ex officio involve the enlarged board, necessary either, in any case, to involve the enlarged board of appeal. So those almost all of the statements, I think I can put it that high, certainly many of the statements you were taking to this morning are not statements of the legal board at all. It's the legal board characterising counter-arguments which, before it dismisses them, it never elevates them any higher than being conceivable. The following part of the decision at 4.7 is about procedural aspects, which I don't think need to concern my lords at all. I certainly don't have anything further to say about them. So that deals with the EPO decision. And I think that's...
You're running out of time.
Well, indeed, I've also run out of submissions, my lord. So unless... Well,
that's a happy combination.
It certainly is. So unless I can assist you further, my lords, that's the case for the Controller.
Thank you.
Please, your lordship, in response to the submissions of my lord and friend, I'd like to emphasize that the nub of this case, as my lord, Lord Richards put it, is the agreed factual basis, as stated by the patent hearing officer, is that the only actual creator of the inventions is the AI machine. DABUS is different than a mere assisting device, as the addendum explained in detail, and as accepted by the hearing officer, it explained how very remote Dr. Thaler was from being the actual deviser. My lord, Lord Kitchen, asked where to draw the line, and I would say that in some cases that would be a very difficult exercise, which can be addressed in such a case. But on the facts of this case, it is not. DABUS is not merely sophisticated equipment. The inventions were not created in large part by a machine. DABUS was not given a goal. It was not given a specific field of activity to invent in. It generated autonomously two inventions and recognized their utility. The difference between that and the general way that modeling software is used industrially is that modeling software has people specifically programming it to solve specific problems, giving it narrow parameters, giving it specific goals, or evaluating the value of its output, and the facts here involve none of that. Dr. Thaler did not engage in any of those activities that might make someone the actual deviser of an invention. There has never before been a patent case in the UK involving such a technology creating inventions in this way. While in other jurisdictions, someone other than the actual deviser could be listed as an inventor, as a legal court of appeal suggested, the European Patent Convention route does not work in the UK because there's a different statutory basis for entitlement and for being an inventor, with no requirement that the actual deviser be disclosed, right? That doesn't assist on Section 13, where one has to do that under the UK Patents Act. It would thus be a material misrepresentation to say that Dr. Thaler is an actual deviser given his role in this inventive process. Lord Hoffman in Yeda said that an inventor must be an actual deviser and not a deemed or pretend inventor under UK patent law. My learned friend referred to Form 7 as non-punitive, but Dr. Thaler here is being punished for transparency. The comptroller's solution to this was just list someone, no one will question it, and in the interest of fairness, you can explain that actually an AI did everything, and I submit that does much more violence to the language and the purpose of the statute, which requires the disclosure of an actual deviser. This certainly isn't a matter of giving credit to a machine. It is not seeking to assert any moral rights for a machine. If anything, falsely listing a person gives inaccurate moral rights to a human being who is not entitled to them. So if anything, the issue of moral rights requires that no person be designated where the inventor is not a natural person under UK tests for inventorship. In our view, there's no need to depart from Yeda. We think our submissions are consistent with that holding. The facts of the case are distinguishable. That case was about two different human inventors or group of human inventors and two different organizations who claimed their rights through those inventors. It sounded perhaps like we did have some agreement that there is a property right in an invention, including at least the right to apply for and be granted a patent, and that is really the right at which we are concerned here. The question being whether Dr. Thaler can have that right through a rule of law other than one previously explored. And since the Court of Appeal judgment, the Tulip trading case does give an example of ownership of tangible property, of ownership of tangible property being the basis for a property right in an intangible. So that's a paragraph 23 of that decision. And paragraph 7, which notes that the Court of Appeal had no dispute that Bitcoin was property. There's another authority to that. You know, in response to the submission that this is a case about what the law should be, we very strongly disagree with that. This is a case about the proper interpretation of a statute. And to properly interpret a statute, our submission is that you need to have in mind the purpose of the statute, and that the purpose of this act was to do these things we've discussed, not prohibit inventions where you can't accurately name a human inventor or get someone to make a misrepresentation about it. And Quintavalle, in our submission, is very on fact with that. You know, third, just to be clear that this was now the positioning of the case in our amended Form 7, our submission is that all an applicant need do when you don't have a traditional human inventor is name no one or say not applicable, as my Lord Legate suggested, and that is consistent with both the literal language and a purposive interpretation of Section 13, and that's what we've done. The patent is granted, no one is named, no one is getting inappropriate moral rights, you know, derivation is clear, and there's not a disproportionate result based on a procedural requirement. The procedural versus substantive point really gets to the purpose of the act, which is, as you've heard, you could put Mickey Mouse, which could be someone's name, or Donald Trump, and no one would question it. And so if you are transparently saying, I don't have a person to name, that shouldn't be a basis for saying, well, now there's a universe of patentable stuff we're just going to kick out of this system. You know, on a few other points that were raised, the Court of Appeal dealt with, you know, how this would impact other standards, like the person having skill in the art, which is the standard for finding non-obviousness in a patent. That is not actually a person, that is a rhetorical tool that judges uses to ask, would effectively an average researcher have found this sort of thing obvious? It is explicitly not based on what inventors find obvious, because too much would be obvious to inventors. And so whether or not AI is effectively an average researcher or being used by average researchers is its own test, unrelated to inventorship and whether you can have AI-generated patents. You know, of course, as Quintavalle points out, there's the fact that Parliament could have considered this is not evidence that they did consider it. There is no evidence Parliament has considered this. Computer-generated works are very different. That is, within the copyright context, it is very different being an author versus inventing something. The standard of sophistication to do that is entirely different. All of our notepads probably have copyright protection. I submit none of us could probably invent anything during the course of this hearing. With respect to the comment about international harmonization, I would say that it is the court's role to construe the Patent Act consistent with its purpose. It is already the case that different jurisdictions can have different inventorship. U.S. inventors on a patent and U.K. inventors on a patent can be different. The U.S. uses a claims-based approach. The U.K. uses a holistic approach. You know, so too with other jurisdictions, including those which have accepted the designation of inventor as DABUS. You know, and this case is live in almost all other jurisdictions. So, you know, they will interpret their patent acts as they feel appropriate. I submit the court should have a view to the purpose of the UK Patent Act, which is to encourage this sort of activity. You know, with regard to the argument that you name a cat, you know, it's a bit of, in our view, respectfully, a distraction and indeed a silly sort of thing to submit. The hearing officer accepted this was an objectively reasonable statement. It is a bona fide statement. No one has ever suggested otherwise than that. You know, in one view, it really doesn't matter what someone puts on the form. It's just their job to make this information public. On another, if they did want to challenge it, you know, if they wanted to challenge Felix the cat, that would be very different than our case, where we did have a hearing with a hearing officer, submitted a detailed addendum, and explained the factual basis for the AI being the inventor. So it's very different than putting a dollar sign or someone fictitious. Nippon Piston was just a case where someone failed to do the form, and then basically said, well, the patent office could have figured it out, or it was their fault for not sending us reminders or whatever. But there was no issue in that case that there was a prohibition on getting a patent, just that they hadn't done the form. unless there's anything further I could assist the court with.
No.
Thank you, my lords.
Does Mr. GM want to add something? Yes.
I don't, my lords. I think we've made our case. Thank you.
Well, the court is very grateful to counsel for their submissions today. We recognise the significance of the challenges to our current law of the development of artificial intelligence, on which a number of people have written, including, I think, Professor, your junior counsel. It clearly is an issue in relation to intellectual property rights and also other property rights, as well as contract and tort. Many issues are coming to the fore in this matter, and it is a chance for us to consider, in the light of your challenge, where we go in relation to patents. I'm grateful also, the court is grateful also, not only to those who've presented the the oral submissions, but those behind them who have assisted them in the preparation of those cases, who must also not be forgotten. We will take this away and give it very careful consideration and try to produce a judgment as soon as is reasonably practicable. The court will now adjourn.